My name is Mejer. Thank you for joining us once again on the English version of Para Ser Legal to Be Legal. Today, I got a great episode for you. 3 things. 1, how is USCIS adapting the times of coronavirus? 2, should you renew your green card or file for citizenship? I can't tell you how many times I get this question. And 3, can your US citizen child file for your green card?
Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
So, how is USCIS adapting in the time of the coronavirus? Most USCIS services have been stopped, at least until May 3rd, 2020. Today is April 6th. That's a whole month. Now, we may get more notices in the future. Initially, it was stopped for only 2 weeks. Then it was extended for another 2 weeks. So what does that mean for you? There are no in-person interviews for green cards, citizenship, asylum, or fingerprinting. Complete shutdown. Last week, or 2 weeks ago, I talked about, hey, if you have a date for any of those, green card, citizenship, asylum, or fingerprinting, while the office is closed, you will be rescheduled. I also suggested don't wait to be rescheduled. Make a request to be rescheduled. The notice that you have tells you how to do that, and keep a copy for your record. Immigration is a mess right now. Don't assume that they're gonna catch it and do the right thing. Now, second thing that they're doing, they finally decided that they don't actually need for you to come in to renew your work authorization. If you've previously filed for work authorization, they've previously fingerprinted you. They took your biometrics. They have that digitally. So what are they going to do? You filed to renew. They are going to run the digital file and renew your work authorization. Unless, of course, you convicted of some crime or something else. So, guys, they've been doing this forever. There's no reason to call you in to renew your fingerprinting. It's all digital. They just want to charge you the $85. So now they're going to charge you the $85, but they're not going to require you to waste a day going to Elizabeth or Newark to get it renewed. Finally. Now, number 3, if you're here on a visa and you can't travel back to your country, USCIS said that they will liberally approve requests to extend your visa, but make sure you file timely. Don't wait until your visa has expired to request additional time. Look, if you're sick with the coronavirus and you're hospitalized and you don't file timely, you're not going to have a problem as long as you file within a reasonable time once you get better. If you're fine, if you're like me, you're working from home, you're not sick, even though you may have sick family members, you're not sick, and you simply let time pass and say, I'm not going to worry about it. Well, they may not give you the time in that case. Be diligent. Number 4, if you have filed for an immigration benefit and you get a request for evidence or a notice of intent to deny, that's where they're saying, hey, you know what? A request for evidence generally means, I've defined it before, but it generally means we think you might get your case approved, but you're missing some information on this issue. Notice of intent to deny, they're saying, listen, buddy, you're screwed. We're going to deny you. But here's the reason why we're going to deny you. So if you have something to address it, show me now. So if that's due during this time, you're going to get more time to respond. Just explain how the virus is preventing you from responding timely. Do what you can and explain why you can't provide certain things. Well, I need a disposition from the court, but the court is closed. That's a pretty darn good reason. I'd love to get it for you. I made the request. Here's the letter, but now they're closed and I don't know when they're going to reopen. Give me more time. That's a fantastic reason. But respond and explain it. Don't just let time pass and say, I'll get to it eventually. No, be diligent. So, second subject. Your green card is going to expire in the next 6 months. Now you need to decide, should you renew your green card or should you file for citizenship? On March 30th, 2020, last week, I discussed in detail the requirements for citizenship. You can see the link below. For purposes of this video, I will assume that you qualify for citizenship. Otherwise, the choice is obvious. If you don't qualify for citizenship, you can only renew. Period. End of story. The only caveat is if you have a conditional green card. In that case, you will need to remove the conditions on the green card before acquiring U.S. citizenship. That could be investor visa EB-5, or the more common family-based petition, marriage-based petition, where you were married less than 2 years when you applied and received your green card. So, take a look at your green card. If it's only good for 2 years, you have a conditional green card. If it's for 10 years, congratulations, you have the permanent one. And if that's about to expire, you should file for citizenship unless you don't qualify. So, in the example that we're talking about, you qualify for citizenship. You listened to the video, you went through all 6 requirements, and you're like, yes, I got them. You do qualify. Now the question is, should you file for citizenship or should you renew? So, reason number 1. Immigration charges you almost the same amount for both processes. It is a crime. Renewing your green card costs them $540. They're going to fingerprint you, but like I said before, they're going to charge you $85 to do that. They have it digitally. You don't actually have to come in, but they're going to make you come in anyway, so you're going to spend your time. There is no interview. They just do a background check. If everything checks out, boom, you get your green card in the mail. And you get to repeat the process every 10 years. So, naturalization, it's $725. You will be fingerprinted, same process, you're always fingerprinted. You will have an interview, and hopefully you'll have a swearing-in ceremony where you become a U.S. citizen. It's a much more detailed analysis that immigration does. Actually, I would probably say that $725 is not enough for the work that they do. But when you compare it to $540 to renew your green card, they don't do crap for $540. They do quite a bit of work for $725. $180 difference? In my opinion, that's a good reason to file for the full thing so you don't never have to do it again. Now, if your green card is close to expiring or has expired, after you file for your citizenship, you can request an extension of the green card for 12 months to 18 months. USCIS will give it to you automatically while your petition is pending. You don't need to renew the green card in order to file for citizenship. That is just wrong information. I've heard attorneys give it. I've seen it online. It's ridiculous. The only time you're going to file to renew the green card first is if you don't have the card and you don't have a copy. If you've got nothing, you need a card or a copy of the card in order to get your citizenship. Sorry, that's just the reality. If you lost it, you got no choice. If you have it, the only reason to do it is if you think you don't qualify for citizenship. But if you think you don't qualify for citizenship, you don't file. You fix it first. I know it's obvious, but the crap I see online with other channels sometimes really surprises me. It's just wrong information. So reason number 2, file for citizenship because they will automatically renew your green card if you ask it. I know, people don't get it. Now, once you're a U.S. citizen, you no longer need to worry about deportation. Yes, folks, in case you didn't know it, if you're a green card holder, you can still get deported. You could still be not admitted to the United States. Just leave the U.S. for more than 180 days and see what happens when you try to come back. You know, they're going to have you're going to have an unpleasant conversation. Oops, I jumped the gun. If you're a U.S. citizen, you can leave the U.S. for as long as you like without worry of losing your citizenship. Another reason, you can file for more family members, and it's a whole lot faster if you're a U.S. citizen and a green card holder. As a U.S. citizen, you can apply for a fiance and for your siblings. I mean, siblings takes forever, but at least you have an option. As a green card holder, you can't apply for a fiance and you can't apply for your siblings. So what you would need to do is marry your wife. It'll take a couple of years, but it is what it is. Filing for U.S. citizenship, you can have your fiance in the United States between 4 to 6 months under normal times, and then get married and be together rather than wait for the next 2 or 3 or 4 years, depending on what country she's from. So, you can apply for fiance, siblings, and your immediate relatives don't have to wait for a visa. Remember, family-based petition, we're going to go back into this in a little bit, has two, for fans of our program, this is going to sound familiar. Family-based petition has 2 basic components. There can be others, but the basis is 1, document the relationship, 2, change of status. If you're a green card holder, once you've documented the relationship and that's been approved, your relative is going to have to wait for a visa to become available. How long? Well, it depends on who you're filing for, and it depends on where they were born. If they're a citizen of Mexico, Philippines, India, or China, they're going to be waiting a lot longer than if they're from the UK or from Canada. Now, if you're a green card holder and you have children who are also green card holders and live with you, and they're under 18, when you file and you become a U.S. citizen, so do they. It's automatic. You still have to file for a certificate of citizenship for them, or you can file for their passports, but they get it once you get it. It's a beautiful thing. Remember, they have to be living with you, they have to be a green card holder just like you, and they need to be under 18. When you get it, they get it. Once you're a U.S. citizen, you get the full benefits from the U.S. government, like Social Security and medical insurance. You can, and more importantly, today, you can vote. And listen, I don't care what your political affiliation is, but it's never more important than it is today. Look what's going on in the world. The government, the countries are shut down. Speaking of now, you should file now before it becomes harder and more expensive. USCIS has already told us they're making the civics test harder. Where you got to read English, Spanish. You got to read and write and speak in English, and also they're gonna increase the filing fees. In some cases, almost double. So don't wait until it's harder and more expensive. File today when it's easier and cheaper. In my opinion, the only reason not to file for citizenship is if you don't qualify. Otherwise, it's a really simple decision. It's only $180 more. Don't wait. Get it done. You should have gotten it years ago. Don't wait. Do it now. Because if your green card is about to expire, that means you've had it you could have filed at least 5 or 7 years ago. You could have gotten it for years. Don't delay anymore. Last subject of today. Can your U.S. citizen child file for your green card? Bear with me, folks. This is some complicated stuff. Every consult that I have, every interview that I do, I have 3 fundamental questions that I go through with every consult. 1, do you, the immigrant, have a path to legal status? That is, by the way, where most immigration attorneys, for most attorneys, stop. They're only interested, do you have a path? Pay me, I'll figure it out. If something happens, if I figure out that you're not qualified, oops, I'll tell you later and I'll keep your money. That is the most often what happens. That's why a lot of people have really been pissed off with immigration attorneys. So 3 questions. Number 1 is, do you have a path? Number 2, is there something in your past that disqualifies you? And there's a variety of them. We're going to talk about some of them today. 3 is, can we fix whatever that problem you have so that you can file? You need 1, 2, and 3. That's what we focus on this Mejer law. If you have a problem in your past and I can't fix it, I don't want your money, I don't want to start the process. Because the only person that benefits will be the attorney, not you. Now, in the context of what we're talking about, your U.S. citizen child, can they file for you? Or better question is, should they file for you? So number 1, they need to be over 21 years old. And number 2, they have to be a U.S. citizen. If your child's a green card holder, he must first become a U.S. citizen to file for you. See the video below about the requirements for how to get citizenship. If you have both, child is over 21 and is a U.S. citizen, well, now we know you have a path to a green card. That's question number 1. Solid. Now let's focus on number 2. Is there something in your past that can prevent you from becoming a green card holder? Today, any mistake you make will result in you being placed into removal proceedings. It's a zero-sum game. You have to be absolutely sure you qualify. Otherwise, don't file anything. I frequently talk about family-based petition and its 2 basic components. First is documenting the relationship. Here we've already agreed your son qualifies, he is your son, he is over 21, and he is a U.S. citizen. That's easy. Second part is that where you change your status. This is where you go from foreign national to green card holder. Now that's either going to happen in the U.S. or outside of the U.S. If you entered legally into the U.S., what does that mean? You were inspected and admitted or paroled. That's what legal entry. If you did that, for example, you came in as a tourist, you can adjust in the United States. You will have an interview at a local field office. I discussed that in detail. You could take a look at our September 9th video of last year where I go into detail. What does the green card interview look like? Now, but what happens if you didn't enter legally? Again, in the context of what we're talking about, you have a path. If you entered legally and you have no other disqualifiers, then there's nothing that disqualifies you. You can file. End of conversation. Go through the process. Now, but what happens if you didn't enter legally? Now you have a problem, because although you have a path to legal status, you have something that disqualifies you, because you're going to need to travel outside the United States in order to change your status. You can't do it from within the US. So for most people in this scenario, travel outside the United States means you can't come back for 3 or 10 years. You are ineligible or inadmissible unless you apply and receive a waiver. So again, here's where it becomes interesting. Number one, do you qualify? Yes. You have a path. Your son or child can file for you. Number two, is there something that can disqualify you? Yes. You entered legally. When you leave, you're ineligible to return for 10 years. Can you fix it? There's a waiver. 3. All right, let's take a look at that waiver. Now, what are the requirements for the waiver? You're going to need a qualified relative. And you're going to need to show that that relative is going to suffer extreme hardship. That's the standard. Who's the relative? It's not your son. He doesn't count. It has to be you, the immigrant, your parent, or your spouse. Your child doesn't qualify. So imagine my mother filed for me years ago, but unfortunately she passed away. She can't be my qualifying relative because she passed away. So my son is going to file for me. But if my son files for me and I need a waiver, if I don't have a parent or spouse, I don't qualify for the waiver. If I don't qualify for the waiver, that means step number 3 is no. So 1, do I have a path? Yes. 2, is there something that disqualifies me? Yes, there is. Okay, can I fix it? No, I can't. What does that mean? Do nothing. Because otherwise, you're just going to put yourself in removal or outside the United States and without the ability to come back. So, waiver is one way to fix it. It's not the only one. Let me give you 2 other examples. So again, question number 1, do you have a path? Yes. Your son files for you. 2, are you disqualified? Yes. You entered illegally. Can you fix it? Well, actually, there's 3 ways. One is a waiver, which is called the Provisional Lawful Presence Waiver. Another one is the Life Act, or 245I. But someone needed to have filed for you before April 30th, 2001. If no one ever filed for you, well, you don't qualify for the Life Act. Now, if you have a son or daughter that's over 21 and a U.S. citizen and was born here, congratulations. That means you were here before 2001. It's possible that someone did file for you because you were here when you could have filed for the Life Act. Now, another option is, what if your child or family member is in the military? That's called parole in place. If you want more information about parole in place, take a look at our August 26th, 2019 video. That's where I talk about that process in detail. Those videos are going to be in the show notes below. For today, you just need to know that if you have a close family member who's in the military or was honorably discharged, that will waive the lack of legal entry. So either the unlawful presence waiver, the Life Act 245I, or military member in the military parole in place. Either one of those 3, you can fix the disqualification and then you can file. You see how complicated that was? You see all the factors that we had to discuss here? It's super important that you talk to a qualified immigration attorney before filing for anything. And here we're only talking about one thing that disqualifies you, and that is illegal entry. Let me give you some others. You were here in the U.S. for more than 180 days without permission. You left and then you came back without permission. You're got a permanent bar for 10 years. You were caught at the border and sent back. Hey, were you deported back? Were you given voluntary departure? Well, if you're from Mexico, you might have just been sent back. Maybe we got to check. If you're from Ecuador and you said you were Mexican and sent you to Mexico, you lied. That's fraud. That's a separate issue that could cause you a problem under certain circumstances. Now, if you were caught at the border and sent back, maybe you were just released and not deported. We got to check. If you are in removal proceedings, or you were, that can affect you. If you were arrested for a significant offense, it doesn't have to be a felony. Immigration is federal. Most crimes happen in the state under state law. So immigration has a different criteria for what it considers important than the state in which you were charged and or convicted. Now, what happens if you filed a petition in the past and were denied? Why was it denied? The basis for that denial could affect you today. Or, the public charge, that's new. Let's say you have a serious medical condition. Even if it's in remission, it may affect you in the future. You don't want to find out that one of these 7 or 8 things can disqualify you when you're outside the United States. So the question isn't can your son, who's a U.S. citizen, file for you. The question is, should he? And that is based on analysis of your past and whether anything there can be fixed. And remember, before you file anything, do you have a path? 2, something that disqualifies you. 3, can you fix it? You need 1, 2, and 3, or you do nothing. Thank you for paying attention for our weekly show, Para Ser Legal, to be legal. My name is Mejer. Please subscribe to our video, share it with others. We're here every week giving you information in detail. We don't do the superficial stuff other attorneys do. We give you the meat and potatoes. We give you what you need to know.